The Federal Divorce Act is going to be changed significantly by Bill C-78. Bill C-78 passed through Parliament and received royal assent on the 21st of June 2019, but it's not going to take effect until the 1st of March 2021, which should give us plenty of time to get used to the changes that are going to happen to the Divorce Act. If you want to learn more about those changes or to read the text of Bill C-78, you should go to the website of the Parliament of Canada or the website of the Canadian Legal Information Institute. Now, while we can access the Divorce Act online and we can also access Bill C-78, what we don't yet have access to is an official version of what the Divorce Act is going to look like after the changes required by Bill C-78 take effect. For that, you can go to the library section of my firm website, and if you scroll down a little bit, you can download a document called The New Divorce Act. This is a consolidation of the Divorce Act and the changes that are going to be required by Bill C-78 and should give you a bit of a snapshot as to what the Divorce Act is going to look like on the 1st of March 2021. Bill C-78 makes a lot of really important changes to the Divorce Act. We're going to get new language to talk about how we parent children after separation. We're going to have a new test to help us figure out the course of action that is in the best interests of children. Spouses are going to have a bunch of new duties, as are lawyers and judges. And, perhaps most importantly for some people, there's going to be a brand new test that the court will apply when somebody wants to move away from somebody else. Having said that, a bunch of things aren't changing. What's not changing includes the basic rules about divorce and getting divorced, the rules about child support and the child support guidelines, and the rules about spousal support. But let's start by talking about the language we use to talk about parenting after separation. Well, we can get rid of ideas about custody and access. Instead, we can start thinking about parenting orders and contact orders. Parenting orders are available to people who are spouses or parents. If you're not a spouse or a parent, what you can apply for is something called a contact order. Parenting orders allocate parenting time and decision-making responsibility between spouses. Parenting time is the time a child is in the care of a spouse or a parent. Decision-making responsibility is a spouse's responsibility for making important decisions affecting the child's welfare and well-being, including decisions like where does the child go to school, if the child is sick, how is the child cared for, what extracurricular activities does the child participate in. Somebody who has parenting time also has the right to make day-to-day decisions about the child when the child is with them, including emergency decisions. They also have the right to get information about the child's well-being from anybody who happens to have it, including the other spouse, doctors, teachers, and so on. Someone with decision-making responsibility also has the right to get information about the child's well-being. Someone with contact, however, has neither of these additional rights. Someone with contact does not have the authority to make day-to-day decisions about the child, and they do not have the right to get information about the child's well-being. Under the old Divorce Act, making decisions about a child was called custody. Under the new Divorce Act, that same kind of idea is called decision-making responsibility. Under the old Divorce Act, a spouse's schedule of time with a child was called access, and in fact access usually referred to the schedule of the time with the child held by the parent with the least amount of time with the child. Under the new Divorce Act, the idea of access is split between parenting time, which is something that spouses and parents have and includes the right to make day-to-day decisions on behalf of the child, and contact, which is something that people who are not spouses or parents have. In British Columbia, in addition to the Federal Divorce Act, we also have the Provincial Family Law Act. That law came into force in 2013 and uses a lot of the same language that the Divorce Act does. Instead of talking about decision-making responsibility, however, we talk about parental responsibilities. But these are almost exactly the same thing, so it's really nothing to worry about. The Family Law Act also talks about parenting time and contact. Parenting time is something that guardians have. If you're not a guardian and you have time with a child, you have contact with a child. Now, let's move on to the best interest factors. When the court is making decisions about parenting orders and contact orders, it is only able to consider the best interests of the child. There is no other factor it's entitled to consider. Under Section 16, there are 3 primary considerations and a whole long list of factors that the court has to consider, including a few that have to do with family violence. These are all listed in Section 16, and as you can guess, it's really important to read Section 16 of the Changed Divorce Act. The primary considerations are listed in Section 16, Sub 2. That section says that when the court is considering the factors referred to in subsection 3, the court shall give primary consideration to the child's physical and emotional and psychological safety and security and well-being. The factors in subsection 3 include the child's needs, the child's relationships with each spouse, the child's siblings, and any other important people in the child's life, each spouse's willingness to support the child's relationship with the other spouse, the history of the child's care, the child's views and preferences, the child's cultural, linguistic, and spiritual heritage, including any indigenous heritage, the spouse's plans for the child's care, the ability of each spouse to care for the child and meet the child's needs, the ability of each spouse to communicate and cooperate with each other on matters affecting the child, and the presence of family violence and its impact on a spouse's ability to care for the child. Related to family violence is another factor that the court is required to consider any civil or criminal proceedings or any civil or criminal orders that are relevant to the safety of the child. Now, when family violence is a factor, the additional things that the court has to think about are set out in Section 16, Sub 4. When family violence is a factor, the court is required to consider the nature, seriousness, and frequency of the family violence, whether the family violence demonstrates a pattern of coercive and controlling behavior, whether the family violence is directed to the child or the child is directly or indirectly exposed to the family violence, the physical, emotional, and psychological harm or risk of harm to the child, any compromise to the safety of the child or another family member, whether the family violence causes the child or another family member to fear for their safety or for the safety of someone else, and, finally, any steps taken by the perpetrator to prevent further family violence from occurring and to improve their ability to care for the child. The new duties of spouses begin at Section 7.1. They include an obligation to exercise parenting time, decision-making responsibilities, and contact in the best interests of the child. Under Section 7.2, spouses have an obligation to protect their children from the impact of the conflict resulting from their lawsuit. Under Section 7.3, spouses are required to try their best to resolve the issues in the lawsuit through negotiation, mediation, and collaborative negotiation. Under Section 7.4, spouses have a duty to, quote, provide accurate, complete, and up-to-date information to each other when their lawsuit involves child support or spousal support. Under Section 7.5, spouses have a duty to comply with court orders, which is a funny kind of duty because that duty exists anyways, whether Section 7.5 says it does or not. And under Section 7.6, spouses are required to say that they are aware of these duties in the documents that begin or respond to a divorce claim. The new duties of lawyers are listed at Section 7.7. In addition to the existing duties that lawyers have, lawyers are now going to also be required to encourage their clients to resolve the legal issues in their lawsuit through negotiation, mediation, or collaborative negotiation. In addition to the existing duties of the court has the new duty at Section 7.8 to consider any civil protection orders, any child protection orders or child protection proceedings, and any criminal protection orders or criminal proceedings that may exist and be relevant to the well-being and welfare of the child. Then, the final part of this, and perhaps the most important aspect of the changes to the Divorce Act, concerns relocation. Under Section 2 of the Divorce Act, relocation is defined as a change in the residence of a child or of a spouse that is likely to have a, quote, significant impact on the child's relationship with somebody with a parenting order or a contact order. There's a couple of important things that come from this definition. First, that the change in residence we're talking about could be the change of just a spouse who's planning on moving without taking the child, as well as how we usually think about relocations being a spouse who does want to move with a child. The second thing is that not every move is going to qualify as a relocation. Not every move is going to have that significant impact on a child's relationship with someone with parenting time, decision-making responsibility, or contact. So, when we're talking about moves that don't meet that definition of a relocation, the person who is planning on moving, whether they want to move with the child or without the child, is required to give written notice to anyone who has parenting time, decision-making responsibility, or contact. The written notice has to say when the move will happen and provide their new contact information and the new contact information for the child. A lot of the same rules apply when a change of residence does qualify as a relocation. The spouse who's planning on moving also has to give written notice to anyone with parenting time, decision-making, or responsibility, or contact. They have to give this notice at least 60 days before the proposed move, and the written notice has to talk about when the move is going to happen, provide their new contact information, and make a proposal about how the parenting order or the contact order could work if the move is allowed to go ahead. Now, someone who has parenting time or decision-making responsibility and gets this notice is entitled to object. They have 30 days to object to the proposed move by filing a form to be specified by the Divorce Act or by filing a court application to prohibit the move. What's important about this part of the Divorce Act is that somebody who has contact does not have the right to object. They have the right to be notified about a move that qualifies as a relocation, but they don't have the right to object to it the way someone with a parenting order does. When a move does qualify as a relocation and somebody objects to it, Section 16.92 sets out a bunch of additional factors the court has to think about in deciding whether to allow the relocation, in addition to the best interests factors that are already listed at Section 16 of the Changed Divorce Act. The additional factors include the reasons for the move, the probable impact of the move on the child, the time that someone with parenting time has with the child and their level of involvement in the child's life at present, whether the spouse who wants to move has complied with their notice obligations under the Act, whether there's an order, arbitral award, or agreement between the spouses that restricts where the child is supposed to live, and whether the proposal that the spouse who wants to move has made about the exercise of a parenting order or a contact order after the move is reasonable. Finally, the court is also required to consider whether each spouse has complied with their obligations under a court order, an arbitral award, or an agreement. Under Section 16.92, Sub 2, there is one factor that the court may not consider, and that factor is whether, if the child's relocation was prohibited, whether the spouse who wants to move would still move without the child. Okay, so the move we're talking about qualifies as a relocation under Section 2 of the Divorce Act, and somebody who has parenting time or decision-making responsibility has filed an objection. Now, the court has to decide, assuming that the spouses can't reach a settlement of this problem, the court has to decide whether the relocation should be allowed or not. And this raises the question about which spouse has to prove what, so that the move either goes ahead or is prohibited by the court. Firstly, if the child spends, quote, substantially equal time with each spouse, it's the spouse who wants to move who has the obligation of proving that the move is in the best interests of the child. In other words, when the child's time is shared more or less equally with each spouse, there's almost a presumption that the move should not happen, which is why the spouse who wants to disrupt the arrangement is the spouse who has to prove that the move is in the best interests of the child. However, if the child spends the, quote, vast majority of their time with the spouse who wants to move, there's almost a presumption that the spouse should be able to move. As a result, it's the spouse who objects to the move who has the job of proving that the move is not in the best interests of the child. However, in those in-between cases where the child's time is neither shared substantially equally by both spouses nor spent with one spouse almost all of the time, in cases like this, each spouse has the obligation of proving that the move is or is not in the best interests of the child. So, to summarize, the things that are changing are that we're getting rid of language about custody and access in favor of parenting orders that talk about parenting time and decision-making responsibility and contact orders. We are finally putting in a good and thorough test to help us figure out the best interests of children, and that's at Section 16 of the Act. Spouses have a bunch of new duties that are listed between Sections 7.1 and 7.6 of the Act. Lawyers and judges are also getting new duties as well. And finally, and perhaps most importantly, we also have a new test for when somebody wants to move away and the move qualifies as a relocation. But a bunch of things aren't changing. The things that aren't changing include the rules about divorce and getting divorced, the rules about child support and the child support guidelines, and the rules about spousal support. And that is the new Divorce Act in a nutshell.